All right, everyone, welcome to the 2020 legal update. As you know, the pandemic has affected everything this past year, including the legislature. The legislature limited the amount of new bills so that there were not as many bills passed this year as in prior years. Unfortunately, the one bill that they did pass affecting associations was significant. And we'll talk about it. It's AB 3182, dealing with rent restrictions. And what it does is it makes unenforceable, starting January 1, just a little over a month from now, unenforceable rent restrictions that don't comply with those in the bill. So if you have a rent cap, as many associations do, that is more restrictive than 25%. So if you have a rent cap that's 20% or 15% or 10%, meaning that only 10% of the units in your association can be rented at any one time, it will become unenforceable on January 1. But the bill does allow you to have a rent cap of 25%. So if you have a 25, 30, 40% rent cap, those will be enforceable. They'll continue to be enforceable on January 1. The other significant rental restriction that it impacted deals with lease restrictions. So if you have a lease restriction, in other words, a requirement that the term of the lease be at least 1 year long, or 6 months long, or 2 years long, those will become unenforceable. The bill will only allow for 30 days. So you have to, your lease restrictions in your governing documents can require that leases be at least 30 days long. Now there's a gray area in there. There seems to be a little bit of wiggle room, that if you can justify something longer than 30 days, it might be enforceable. It's unclear, but it might be. So for example, we have a client that's a high rise with one elevator. And if they have a 30-day rentals and they just roll over every 30 days, they believe that their residents will not be able to use the elevator because there are going to constantly be people moving in and out. So they're going to keep their 1 year rent restriction or lease requirement. And but other than that, if you can't justify anything longer than 30 days, it will become unenforceable. All right, another one that's significant, a lot of associations have this in their governing documents. Their CCNRs require that a buyer live in the unit or own it for at least 1 year, or sometimes 2 years, or I've seen some with 3 year requirement before they can rent. So if that is a requirement that's in your CCNRs, it will become unenforceable on January 1. Now, what remains enforceable is your ability to prohibit short-term rentals. So you can still prohibit Airbnb or short-term or like weekend rentals, vacation rentals, anything that is less than 30 days. So this would be Airbnb, and you can see in the list there are a lot of different companies out there that will book like Airbnb for vacation rentals, short-term, weekend, 5 days, 10 days. Those you can prohibit. And what we're doing is we're recommending that you amend your documents to say two things. One is that prohibiting short-term rentals and including the 30-day minimum lease term requirement. And we've got language that we use to deal with the transient or hotel-like usage of units. Okay, another thing the bill requires is it mandates all associations to amend their governing documents by December 31, 2021, so by the end of next year. And if you don't, there's going to be a penalty of $1,000 for associations that don't comply. Now that then brings up the issue of amending CCNRs, because it's not easy to do that. So what we're recommending to associations is that boards amend their rules immediately so that they've got restrictions in place, since whatever they do have in their documents that don't comply will become unenforceable on January 1. The other thing is that they can amend their CCNRs to make them compliant. Now, to avoid taking it to the membership, going through that long process of trying to get the membership to vote and to approve, which would likely fail, because not enough will vote, or they might even vote it down, we're recommending that boards, pursuant to the statute, just amend their CCNRs to make their existing rent restrictions compliant with the statute. So if you have a rent cap and it's a 20% rent cap, then we believe the board can, and we're recommending the board just authorize us to prepare an amendment and to record it saying that it's now 25%. The same thing with lease terms. So if they have a lease term requirement of 1 year, we amend the documents taking it down to 30 days. That brings them into compliance. That means that they'll have enforceable restrictions and they avoid the $1,000 penalty. All right, another one is accessory dwelling units. Last year there was a statute that went into effect January 1 of this year that requires associations, not condominiums, but planned developments, allow for accessory dwelling units, meaning that their garages can be converted into apartments. And they can also build a dwelling unit in the backyard so that you have a single family home that now has 3 families living on the lot. So this is affecting planned developments. So if they own the lot, per statute, they can make these changes. But what they did this year was they want to accelerate it, the process. So the legislature basically now is mandating building departments to just give ministerial approval. So it's an accelerated approval process where if somebody comes in and says, I want to convert my garage into an apartment just over the counter, they can approve that. So we're going to see more of that happening with associations. Probably in this next year, we'll see more and more requests for conversions for approvals. And associations cannot say no, so they're not allowed to say no to the process. And of course, this is going to lead to parking problems as more and more garages are converted into apartments, overcrowding of amenities, and rules enforcement problems. So what we're recommending is that boards start adopting architectural guidelines dealing with these issues and start looking at rules enforcement issues and how they're going to handle this. Okay, so that's it for the statutory changes, the bills that came down that we think are relevant to associations. There are a large number of cases as well that were decided this past year, but I'm only going to show you a few of them that I think are interesting and may have impact associations. Coley v. Eschaton is one of them, and it deals with directors who breach their fiduciary duties. Now, as you know, directors are held to a higher standard, and they have, once they become elected to the board or appointed to the board, they are held to that higher standard, and that is the fiduciary duties. And if they have a conflict of interest, they are required to disclose that conflict and then recuse themselves from whatever the decision is involving that conflict. Well, in this case, in the Coley case, directors were employees of a company that owned a majority of the units in the association. So you've got a majority of directors who are on the board, appointed because the company owns a majority of the units. And one of the conflicts here is that the compensation of these employees who are now directors sitting on the board is based on the employer's performance. So what that means is the units that are owned by the company, if the company does well with the units, the directors that work for the company get paid more money. So what happened was these directors started shifting costs from the company-owned units to homeowners that on their individual units, and they got sued. And what the court did was it held the directors personally liable for their breach of fiduciary duties. So normally court directors are not held personally liable for the decisions they make while they're on the board. In this case, they were, because they were in breach of their fiduciary duties and they were acting not in the best interest of the association, but in their own personal best interest because they got compensated more for the decisions they made on behalf of their company. So it's just a lesson to board members, you need to be very careful that the decisions you make are in the best interest of the association, even if it's not necessarily in your best interest. So just keep that in mind when you sit on the board and how you approach things that are brought to the board that you need to make decisions on. Okay, the next case is Davis versus Echo Valley Condominiums. And this is a federal case. And the fact pattern is that Davis, one of the homeowners, she suffered from asthma. And she alleged that the association discriminated against her, again, based on her health, because the board refused to ban smoking in the building. She wanted the board to ban all smoking in the building, including inside of units. And the board didn't do that. And so she sued. And the court determined that a smoking ban, this is good news for associations, is not a reasonable accommodation, since it would intrude on the rights of other residents to smoke in their units. So the reason why it's good is that there were other alternatives that were available to her that could have been implemented other than the drastic requirement that all smoking throughout the building be banned. And that is, she could have sealed her unit, she could have put in HEPA filters, and she could have, the board could have required surrounding units that had smokers do the same thing, so smoke wouldn't drift from their units into her unit. And that way it preserved the rights of people who did smoke to smoke in their units. Now, could the board have banned smoking entirely? It would have required an amendment to the CCNRs. And the membership could have voted on that, and they could have said, yes, we're going to ban completely all smoking inside the units throughout all the buildings. So that is an option, and a lot of associations are now doing that. They're adopting complete bans on smoking entirely, in not just in the common areas, but including in the units. So boards have that flexibility, and this is something when it comes up that they want to talk to legal counsel on what is the best approach on dealing with these questions, these health issue questions that are brought to the board's attention. The next one is Jepson v. Lee, and here it involves social media, in this case Nextdoor. Many of you are going to be familiar with Nextdoor. I'm sure that a lot of you have that active in your community. Other forms of social media are also used by different associations, such as Facebook. And here there was a dispute between two neighbors, Jepson and Lee, and they signed a settlement agreement involving one neighbor's dog killing the other neighbor's cat. So Jepson's dog killed Lee's cat. And it contained a non-disparagement provision, meaning that once they signed the settlement agreement, the two neighbors could not say anything bad about each other. Well, Lee then posted a hostile message on Nextdoor about Jepson, and Jepson sued. And Lee filed an anti-SLAPP motion. And what that means is SLAPP deals with strategic lawsuit against public participation. And in this case, he was seeking to have the lawsuit knocked down because of something he spoke, in a public forum, and free speech should be the prevailing right. And the court in this case disagreed and said that the postings on Nextdoor is not a protected activity, and that he was in breach of the settlement agreement, the non-disparagement portion of the settlement agreement. So this is a lesson for boards that they need to be careful about what they say in a public forum, and we recommend that board members and managers stay off of things like Nextdoor. But if they are going to be on it, and whether it be Nextdoor or Facebook or some other form of social media, be very careful about what you say on these media. We would prefer that you not even be on them. All right, next one is Parnell versus She. In this case, the Parnells obtained a restraining order against She because she was sending just hundreds of emails to not just the Parnells, but to the Parnells employer and to the association about the Parnells. So they were being copied. And 307 months. And they were designed to create distress for the Parnells, which they did. And so the Parnells went into court and obtained a restraining order. And the restraining order was that she was ordered not to contact the Parnells, to stay 5 yards away from them and their son, and 100 yards away from their dog. So I don't know what she was doing to the dog, that he's ordered to stay 100 yards away from it, but the dog was included. And he was also ordered not to contact Parnell's employer. And where this is important is just to make you aware that you are able to go into court and get restraining orders to keep a homeowner from harassing board members. In this case, it was neighbor to neighbor, but the same thing applies to boards. And we've gone into court and we've obtained restraining orders where you have an owner that is harassing the board, and in this case, using just emails, sending hundreds of emails. And one of the instances where we obtained a restraining order, it did involve emails. So just be aware that you have that remedy available to you. Okay, as I said, I've only given you a few of the cases and a few of the new bills. If you want to track all of them, you can go onto our website, and if you'll see up at the top here, the crossbar, it says new laws. And if you click on new laws, it takes you then to this page, new laws and legislation, and you see we have them grouped by year, 2020, 2019, 2018, 2017, and so on. If you click on 2020 new laws, it takes you then to a page where it talks about the legislation and the terminology used by Sacramento in dealing with the legislation that comes through. And we list each of the bills that affect associations, and we talk, you see it's marked whether it's chaptered or whether it died in committee. And you can see we also have the blue part where it's linked, and if you can click on it, it'll take you straight to the bill so you can read the bill itself. If you scroll down, you'll also see that we have cases, and we have all of the case law listed, and those are also linked so that you can not just read the summary, but you can click on the link and read the entire case. So for those of you who like to follow what's happening with all the new cases and the bills, you can go straight to the website, and we keep it current, we keep everything listed. So it's a nice way for you to just to follow what's happening both in the courts and the legislature. So this is it for our update for 2020. And we will, again, be available to answer questions. If you have questions, by sending through the website questions to me, but also just to look at going to the website to find summaries on all of the statutes, all of the bills, and all of the cases affecting associations. So for now, this is it for 2020 Legal Update, and we'll see you next year for the next update. Thank you very much.